Alrighty, we are good to go, and this is the drop-in session number 2 for Contract B on this wonderful Monday evening, the 24th of July. Don't loads of people celebrate like Christmas in July tomorrow? Hey, Merry Christmas, everyone. That was random. So today I thought what we would do, my kids are yelling in the background. I thought what we would do, given the discussions that have been going on Facebook, is we would have a little look at equity, because whilst I was in the middle of a discussion with somebody, in fact I think it was Angelina, I was saying, oh, you know, of course equity's jurisdiction hasn't been enlivened here, and I thought, oh, they don't know when equity's jurisdiction has been enlivened, and oh, they haven't probably come across a whole lot of equity before, so it's probably a good idea to have a short primer on equity. I don't pretend to be an authoritative expert on equity. I did teach it many, many years ago, about 20 years ago. I have a reasonable handle on it, but you don't have to really worry too much about the niceties of equity, and believe you me, there are many niceties involved with the whole issue of equitable principles, equitable maxims, equitable remedies. You will go into those ad nauseum in your equity and trusts units, or I think there's some discussion of fusing them into one unit. It is a fascinating area of law, and it comes much later in your degree. So you can you can just take this as kind of the first year contract B guide to equity, if you will. Hi Peter, how are you? Nice to have you with us. What I might do without further ado, that really didn't make sense, was share my screen, and I haven't tidied it up before I've shared it. Never mind, you can see what I'm working on here. Okay, cool. So this is us, and I have given a rather inflammatory picture on the front page of my explanation for this evening, to kind of flag for you that this is all very tongue-in-cheek, and this is a Contract B introductory guide to equity. It's certainly not anything detailed that you'll need for later. It's not really even anything that you need to take notes on. I certainly will be putting these notes up online for you in Moodle, so you don't have to worry too much about that. I based my notes on a nice little introductory chapter of the text on equity and trusts, and a nice Oxford University Press publication on equity and trusts. And it pretty much gets across everything that we need to know for our purposes. And I just put in this little photo because, you know, there's always this tension between the common law and equity. And I don't even know why. I have this visual image that pops into my head of two opposing groups at a party, and on the one side, you know, you have those that come with their horn-rimmed glasses and their neckties and their suits and their very nicely ironed shirts and their polished shoes, and they're standing on the one side, and then on the other side you have the woohoo, it's party time kind of hippies, yay, you know, let's do what we want, say what we want, think what we want, feel what we want. And I kind of feel like that's the equitable answer to, to common law. And that's, that's almost how it was kind of fought out in days gone by. So hopefully I've infected you with my bad visual representation of the opposing nature of common law and equity, and we can zip forward into a brief discussion of same. Now, equity. We've already touched up against equity. We've kind of brushed up against it a number of times in our discussions already. We had discussions surrounding the equitable nature of the remedy of rescission when we were looking at mistake last week. And one of the reasons why it cropped up for discussion was the fact that in the scenario that we had last time round, there was no intervention of the property being on-sold to anybody else. Remember, we had Lord Mitchell of the Seven Orbs, and we had Jordan Roberts, or Robarts, who was the rogue who sold the book. It was a bit different to some of the cases that we looked at, like Lewis and Avery, where you had the transfer of a car by contract, and then the innocent seller of the vehicle didn't get paid, but the rogue had already on-sold the vehicle. And there was, some discrepancy between what the common law would say should happen, which was the Ingram and Little case, where they said, no, sorry, the whole contract's void according to common law, and therefore the sisters Ingram could get their vehicle back because no title had passed because the whole contract was void. So the poor old ultimate purchaser down the line there, they lost out, and the person that was perhaps a little bit more to blame in the whole situation got their car back. Then you had Lewis and Avery saying, oh, look, this really is not a good result. It's a little bit harsh, a little bit unreasonable. We think that in terms of equity, the contract should not be considered void. It should be considered voidable only. And that means then that the ultimate rights will be left to be sorted out according to whether or not the plaintiff who's coming to the court has had some intervening factor to stop them asking the court for rescission. Have they affirmed the contract? Have they acted with some kind of delay or latches, as we call it? Has a third-party right intervened? Now, where that third-party right intervenes, obviously your right to rescind was destroyed in Lewis and Avery, and the ultimate purchaser down the track, who was considered to be the more innocent of those two innocent parties, the one that got defrauded by the rogue and the one that ultimately bought the vehicle, the one that ultimately bought the vehicle won out as the more innocent. So we know that there is a difference between the results sometimes, not always, but sometimes, where equity will step in and mould the result in a case according to what is perceived to be the good conscience dictates of that particular circumstance. Okay, so we've already kind of brushed up against the fungible, kind of spongeable nature of equity. It looks around at the circumstances and says, well, what really should be happening here? And it tends to tailor a result to that perceived need. So that is the whole basis of equity. Unconscionability. Yep, question?
Can I ask a question?
Yeah, sure.
I don't even know if I'm going to be able to put this into words. So in a contract where there's a third party, and so the availability to rescind is gone, because of, obviously they're the more innocent party. Does that mean that then that the first person who was defrauded, does that take away their ability to apply for damages as well? Do damages only exist where rescission exists?
No.
Or are they separate?
Separate.
Okay, so say in the one Lewis v. Avery, so say they can't rescind the contract because it's passed on to that third person. Could Lewis then still, can they still then make a claim for damages against the rogue for their loss?
Sure, but you can see obvious practical difficulties there, obviously, because oftentimes the rogue has already absconded, and B, usually the rogue will be impecunious. That is, they won't have the money to pay. So you can see that the position that the originally defrauded person is left in is certainly not an ideal one. Yes, and that's where, equity can't be perfect. It can't be all things to all men, but what it does do is it weighs up what it perceives to be the more pressing need in a particular circumstance. And in that situation, whilst that party that was defrauded is left in a bit of a lurch, equity would say, well, you know what? Yes, you are, but of the two parties here, we have to fall down on the side of the more innocent, which was the ultimate purchaser. And really what you should have done is check that, as we were looking at last week, check that identity better if that truly was a material term of the contract for you. Yes. And it's that failure then that will lead equity to weigh the other ultimate purchaser's rights over and above the originally defrauded party's rights. Does that make sense? Yeah. They're often not left in a great position, but you know what? They are culpable to some extent. Yeah. So unconscionability is the whole basis for equity stepping in, and there's a few different avenues where equity's jurisdiction is enlivened, and we're going to come across quite a number of these in Contract B, and exploitation of vulnerability is one of them, and a fairly sizable one of them. And here we have unconscionable conduct and also undue influence, which we will be discussing in our unit. You also have equity stepping in where there's been an abuse of confidence, and that will be discussed with you guys in your equity and trusts units. It particularly relates to the kind of relationships that you get between fiduciaries, so a trustee and the beneficiary of the trust, which in a wonderful Latin term is called the Sedacare trust. So the trustee and the Sedacare trust, that is a relationship of trust and confidence. Fiduciaries, apart from trustee, you'll see the fiduciary concepts creeping into things like contracts of insurance, where you have contracts Iberime fide. You'll also have equity stepping in where there's been a breach of confidential information, and that's a really interesting one. That's one that crops up. If you do intellectual property law down the track with me, confidential information is a big one there. And the equitable action for breach of confidential information is an interesting little beast. Nice little case law history on that. So that's another time when equity will intervene. Unconscionable insistence or denial of rights, and this is one that we will crop up again against in our unit when we look at estoppel. Okay. And then you've got unjust retention of property, which you'll be looking at. You'll probably look at that in your equity and trusts unit. You may also do a bit of preliminary discussion of it in property. So that's kind of the landscape of where equity will creep into your other units. A brief history. I'll put a heading here. Very, very brief and unsatisfactory history. Okay, so starts way back in the 1200s, actually. Way back when I was just a girl. You had the whole development of common law happening. And, you know, that's all well and good, not a problem there. The only difficulty is that in the laws, I guess, wish to evolve in a fairly reliable and predictable fashion, it became extraordinarily strict. And sometimes the results that you ended up with at common law, in the common law courts, was quite harsh. So what happened was you started getting people that were unhappy with their decision appealing to the Crown for assistance. Can you please help me? I've fought the good fight all the way through the common law courts, and now look at this decision that I'm lumped with. How can this possibly be fair in the circumstances? And so you had the Crown looking into decisions that had been made and sometimes providing relief, sometimes not. Now, that was all very good, but you see, once the word got out that these decisions might be turned around, the workload shot through the roof. So you find then in the 14th century, you have appeals being sent to the Lord Chancellor. And this is where you got have you heard of Chancery courts before? The courts of Chancery? It probably should ring a bell. I guess if you've been looking at your citations diligently, as you've been going through the various different fairly landmark decisions, I guess, you come across in your first year of law school, some of them inevitably will be from the courts of Chancery, the old ones, the old British ones. And this is where it all harks from. So the Chancellor heard appeals from common law courts, and it was an important factor here that the Chancellor belonged to the church. So obviously he was considered to be, you know, well-versed in matters of conscience, okay, which is obviously important for equity. And if any decision was made to change the common law result, it was always justified as being based on conscience. Like, what does good conscience tell us should happen in this circumstance? Now, obviously, that sounds all well and good kind of on a theoretical level. But the reality is, you know, in a system like ours where precedent is so valuable, what's going to be the result that, you know, good conscience dictates in one case is not going to be the same in another case or another case or another case. So you had this growing concern that equity was really quite a capricious thing, and it got described to one audience as being rather like, you know, saying, well, you know, equity decides things according to the length of the Chancellor's foot. You Now, of course, what one chancellor's foot, however long one chancellor's foot was not the same as another, nor another, nor another. So the point being, you know, you couldn't depend on equity as this kind of reliable body of case law. And there was ongoing tension between the courts of common law, you know, the suits on the one end of the party dance floor, you know, that have their nicely ironed shirts and their horn-rimmed glasses. You know, you had the common law people going, oh, tut, 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 really, this is not terribly a good thing. You know, where common law makes a decision, there's been a lot of effort and time invested in this, it's dependable, it's solid, it's ironclad, this is just how things should be. You shouldn't have the ability of the Chancellor to go in and meddle into things when the good sense of a justice of a common law court had held otherwise. And it all came to a head in a case in the 17th century called the Earl of Oxford's case. I think it was about, don't quote me on this, I think it was about 1640-ish. And it was rather interesting. Plaintiff sued the defendant. Yeah, so what? Okay. The plaintiff actually stopped the defendant's witness from appearing in court. So the defendant's case was rather weaker because they couldn't get their witness into the witness box. Not surprisingly, the plaintiff won the case and got their decision, according to common law, on the facts as they had been presented to the court without this witness testimony. Now, the defendant was rather miffed at this, rather understandably, and appealed to the Chancellor. Guess what? The Chancellor says, you're absolutely right. The plaintiff shouldn't be able to win their case by doing something so unconscientiously inappropriate as preventing a witness from giving their testimony in court. So they get injunctive relief from the Chancellor, and then all, you know, what breaks loose in the common law courts, and there was a lot of tutting and finger waving, and eventually the Lord Chief Justice in the King's Bench, says the defendant, that's almost like defecated, isn't it? I think I'll put that in full. Defendant. Okay. Defendant. Defendant acted unlawfully in appealing to the Chancellor. So, you know, the gloves were well and truly off. Finally, the King had to step in, good old King Jim I, and he says, no, actually, I'm going to issue a decree that says if a plaintiff in equity has a good argument, then, you know, we're not going to leave them to languish, they said, at the hands of the common law. Equity will step in and fix the situation if it possibly can. So the jurisdiction of equity was very clearly established in that case. And that's all well and good. I guess the question we are left with at this point then is, well, so what? The so what is this? There were a number of problems that we had, as I said, with the whole body of equitable principles. It was seen as, capricious. The other problem was the courts were extremely slow, unwieldy, and the whole process was very uncertain. So there were problems there in the process side of things. And because it had developed as a separate and alternative source of remedies and assistance compared to the common law, then the whole procedural side of things was also separate. So if you were seeking an equitable remedy, you would start your action in an equitable court. right? If you were seeking a common law remedy, you would start your action in a common law court, yes? So everything was separate about common law and equity at that point. But there were problems with that, obviously, because what if you started in the common law courts and then found that your better remedy was in equity? You had to start the whole thing again. Oh, my word. So how much wasted time, effort, money, and this is, I mean, everyone knows how much it costs to sue, right? One thing I want you to keep in mind in the back of your mind during your whole excursion through law school, it's not just the time, the effort, and the money that you have to plough into legal proceedings. It is the psychological toll, the social, emotional toll it takes on parties to litigation. And it's a really super serious matter. I don't know if any of you guys have been involved in litigation, but it is an enormous burden to take on. And to have to get through or partway through a proceedings and have to start all over again can be soul destroying. So this was a super big problem in the whole procedural side of things. Sorry, someone just said, yes, the psychological toll is grueling. I have been involved in litigation and I'm still involved in litigation. It's been going on for almost 2 years now, and I can tell you it's massive. It's really massive. So when you're advising, you know, in law school, yeah, even as family, it can be horrific. You're absolutely right. And anyone who knows someone who has been through this, it's massive. It really is. And this, I mean, we digress a little bit, but you will see down the track in Contract B that you usually cannot get damages for psychological loss when it comes to breach of contract. So, you know, I've often wondered about that because, you know, the whole psychological element I think is too easily dismissed, but that's an argument for another day. But I just wanted you to have in the back of your mind, if you had to pay for mental health, I want you to have in the back of your mind when you're advising all the way through law school, yes, you're advising strictly for the purposes of most units, you're advising strictly on the legal rights as they are presented to you and as you have interpreted them, and that's all well and good. Just in the back there, you know, when you're advising clients, you need to take that whole psychological, emotional thing into account. Yes, you know someone that's in a contract battle as well. Look, it's not a pleasant process, and it is something that you have to think twice about, which is why I always laugh at the kinds of scenarios that you guys are given in Contract B because, you know, no one's going to sue for a $100 book like last week. You know, even a $30,000 loan, oh, I bet it has been, Angelina, even a $30,000 loan like we're looking at for Miss Rep this week, you know, unless you qualify for legal aid, you're not going to be suing in any kind of protracted, brings back to our level, yeah. You know, it takes around about, and this is just a rough rule of thumb, an average, about $150,000 to litigate a fairly simple matter to a conclusion. So using that as your rule of thumb, then, if the quantum of what is at stake is $30,000, like for this week, it's going to be pretty tough to say to a client, go ahead, sue, because, you know, those legal costs will blow out extremely quickly. I had, the usual price for 1 day of barrister's time is about $8,000. And they'll normally require about a $10,000 retainer. So that just gives you a rough guide. My kids are sending me texts, sorry. That just gives you a rough guide as to, you know, the real world implications of contractual disputes, you know. But getting back to equity, obviously we had to sort the whole thing out with this procedural problem. So we had the Judicature Acts. And in the 19th century, it was sorted out. Eventually, all of this was adopted across Australia. Not long after, actually, we weren't too far behind. So equity has its own special place in our hearts and minds in law school. And that's kind of the way it all came about. Now, in deciding matters of conscience, equity is not completely left to its own devices. Equity has a number of maxims that guide the application of equitable principles in any particular circumstance. And these are handy. A couple of them we brush up against in Contract B. Generally speaking, now this is a difficult one to kind of wrap your head around. Okay, just backing it up here. The Judicature Acts said if there was a dispute between common law and equity, equity has to prevail, because if it's going to mitigate the harshness of a common law result, then it has to be able to ride over the top of that common law result. Yes? But it will only do so if the circumstances are such as to warrant the intervention of equity in those circumstances. So we say that equity's jurisdiction has to be enlivened in order to provide an equitable remedy or apply equitable principles. Now, in order for that to happen, it's not just that there was some kind of, you know, rough unfairness in the situation, because you know what, life's unfair. And if that was the case, you just would never have a stable, consistent body of common law that held any merit. Equity would just be jumping in all the time in any old perceived issue of unfairness. So it has to be more than that. Discretion of courts around circumstances. Anthony, do you want to just pop your mic on and just ask that question in a little more detail for me?
Yeah, I see a lot of the reading talks about discretion of the courts, but it's in accordance with the circum surrounding what's going on with the big picture. Is that where it goes?
Yes, absolutely. And the discretion, equity's intervention is only justified if there is some kind of serious exploitation in an unconscientious fashion of another party's, usually in contract, another party's vulnerability. Okay, and these principles will be fleshed out much more when we talk about undue influence and unconscionable conduct in week 4. But yes, it has to be something much more than just a little bit of unfairness for that equitable jurisdiction to be enlivened. Or sometimes the courts do say, well, you know, the equitable discretion will only be enlivened if these particular circumstances are appropriate.
I see. Sorry, just to dive back in, it was talking about extreme circumstances around undue influence and duress. But when it comes to mistake, is it the same kind of level, or is it down a couple of levels from extreme?
Well, when you think about it, it's the same kind of litmus test that will apply for equity to jump in any circumstance. And they, just to hark back here, these, where are we? I think I put them here. Exploitation of vulnerability is the big one for us. So there's been some form of unconscientious exploitation by a stronger party of a vulnerable, weak party. But there is also other times when that discretion can be enlivened. There's been an abuse of a confidence that's being entrusted to someone. There has been some kind of extremely inappropriate denial of rights or insistence of rights, such as to qualify as being unconscionable. Do you see what I'm kind of getting back to? Here we've got another term, unjust retention of property. So it's just not that it's a little bit unfair, but it's one step more than unfair. There's a degree of seriousness here that really means that you just can't leave that situation to stand unremedied. Yep.
Yeah, well, the way you explained it in Khan made a lot of sense. So if it works the same way throughout, it makes pretty good sense.
It has to be, like I said, something, you'll see different terms used in different cases, but you'll get a lot of reference to that something's unjust. It would work injustice. You'll see a lot of reference to unreasonable exploitation, and that's usually in the undue influence cases. You get a lot of reference to one of the parties' special circumstances, what some cases call a special disability or serious disadvantage, a particular vulnerability that gets exploited for another party's gain. These are all, I guess, different ways of saying the same thing. It's something that's gone beyond, mere unfairness, and it's something that a court just can't feel right about leaving. Yes, it has to step in and try and do something. So that's the kind of flavour that those terms are intending to portray. Different terms in different cases, but essentially the same core element, if you will, which is that serious level of unconscientious behaviour.
With that, they're very particular on when people haven't taken reasonable care and stuff in their own hands. Hey, like
absolutely.
There's
another one that's here, which I love, but it's not in that chapter. Equity helps those who help themselves. That is, if you've done everything right, and you're the party that's been left on the lurch, then there's every chance that equity will step in to help you. But if you've sat back, if you haven't protected your own position, if you haven't checked that party's identity, if you considered that identity was a material term of the contract, if you haven't duly, there's another one. I'll talk about that when we talk about mistake. But yes, there is that element of, you can't just languish and expect equity to swoop in at the end of the day and save your position. It's like, Commonwealth and the McRae and Commonwealth Disposals Commission. I love that case of common mistake. Do you remember that one from your week 1 readings? And the Commonwealth Disposals Commission said, hey, we're going to call for tenders. There's this ship lying off of Juramond Reef, and we're going to call in tenders for you guys to come and salvage that ship. You can sell it off, and, the highest bidder will let you go and salvage the ship. And McRae came in, was the winning bidder, and then fits out a whole expedition, and there is no ship on Juramond Reef. In that kind of a situation, the court says, you can't try and play, oh dear, there's just been this terrible mistake, and expect that you're going to get some kind of relief from equity. In common mistake particularly, courts will be very strict, and you are usually left with your common law remedy, because there is usually a party. When you look at Party A and Party B, there usually is one of them that has promised that a certain thing will exist, and that was certainly the case in McRae. I mean, the court said, if anyone, who was going to be the person that knew whether or not there was a ship lying off Juramond Reef? It should have been the Commonwealth Disposals Commission. Yes? You know, you can't just languish back like that and then expect equity to swoop in. Oh, thanks, Marcus. No worries, mate. See ya. So that's that. There's your equitable maxims. These are, so equity generally does follow the law, and that is particularly the case with common mistake. But if there is an unjust result, then equity can prevail. So it seems a bit hard to get your head around, but yeah, that's generally the case. Equity won't suffer a wrong to be without a remedy. So this is where you start to get your tailoring of your equitable remedies. Yes? Tends to be much more flexible than common law results. You're off to const. Okay, bye. Yeah, you can explore those maxims at your leisure. We've already come across first in time prevails. That's usually the case unless you're talking about, so that would be the case. I won't go too much into that. That's often discussed in trust transactions. Sorry, I've got more people saying goodbye. Bye, Angelina. See you next time. Equity assists the diligent and not the tardy. This is a big one for the equitable remedy of rescission. Yes, if you delay, if you affirm, then you lose your right to rescind. Yes? So that's a very brief potted history of equity. Do we have queries on that? Do you have time for another, say, 5 odd minutes? Yes? Okay, because what I'm keen to do is to open your mics now. How many do we have here? Okay, so jump in, guys. What I'm keen to hear is, and this is actually a really important discussion, so you'll be glad that you stayed for the last 5 minutes. What is rescission a remedy? What is it an alternative to?
It's an alternative to making amending a contract so that it basically is unfair and has faults in it.
Yes. So you can either try to get the contract rectified.
Yeah. Yeah.
Which is usually hard. But what I'm seeking here is what does rescission do to the contract?
It voids the contract. It puts the parties at the position that they were before the contract was formed.
Beautiful.
Is it void ab initio? Is that the word for the alternative to rescission?
Ab initio, yes. Ab initio. It unpicks the contract ab initio before the parties contracted. Now, what is so effectively it ends the contract. But more than this, it unpicks the contract. Yes?
Yes.
It's as though it never
existed.
in the first place. Now, what is the other way that you end a contract?
Can it just be terminated with like all losses cut?
Beautiful. Termination, that is exactly what I wanted you to say. This is the other way a contract ends. Now, what's the difference? Does anybody know? If I say to you, oh, thanks very much for that lease agreement. I know it goes for 12 months, but I'm moving out next week. And I terminate. What is the effect of termination?
The effect of termination is that one party has had a benefit from that contract and the other one gives up the consideration. It doesn't make the consideration, the full consideration of the contract. Whereas if you rescind a contract, there's no, the contract is as if it has never been. So there's no consideration given, there's none offered.
Exactly. So this is the way I want you to contrast these two concepts in your brain. Rescission unpicks that contract as though it never existed in the first place. Termination stops a contract dead in its tracks, but everything that existed up to that point stays on foot. Yes?
Yeah.
Really super duper important, okay? Because if there are obligations, rights and obligations outstanding, then your remedies will be accordingly. So your remedies for termination and your remedies for damages for breach that result in termination of a contract are very, very different to the kinds of remedies that you're going to get with rescission, okay? When you rescind a contract, the only thing in a court's mind, and here, bear in mind, damages are a very separate issue here. When you're talking about rescission, the only thing in the court's mind is what can we do to get this party back into the position that they were in at the beginning of the contract. Yes? That's all they're worried about. And the measure is we need to get that party back into the position as if the tort had never been committed. Yep. So if they are left with, if they bought property for, like last week, $100, and they're left with property that's worth $25, what's the measure of your damages? Jump in. Measure of your damages.
Would it be to repay the $75 difference?
Yes, because that's the amount that you're out of pocket. The court says, what loss have you suffered as a result of this tort? And the loss you've suffered is that $75 difference in what you paid and what you actually got, what it's worth. Yeah? Now, when you are talking about damages that accompany rescission, it is an extra and a different remedy to rescission itself, okay? So the only thing you're talking about in rescission is the kinds of orders that a court will make to put those parties back into their start position, okay? Now, there are some other things that some other losses that might flow as a result of that tort, be it, misrepresentation or whatever, deceit is the tort. So where there have been additional losses, you might have purchased additional property, you might have sunk some other costs, those things might be restored to you as part of an award of damages that would sit alongside your remedy in rescission, okay? So you've got your actual loss, your $75 that you're out of pocket, the court will unpick things. You give the book back, and or you keep the book, and it'll give you your $75 back. They'll make those orders, but then if there are additional things that you've lost, then you can claim them in damages, right? That then hopefully should get together the plaintiff back to their start point. Now, when you're talking about termination, the kinds of damages you can get following breach, so generally speaking, we call these damages in contract, okay? Where you're looking at damages in contract, these are a beautiful thing because they open up many more things that you can claim, okay? Now, the object of damages in contract is not just to put you back into your start position, because we're not worried about rescission here. Where everyone knows there's a contract. It's just been stopped dead in its tracks. So what does the court want to do with damages then? They want to get that plaintiff not into the start position. Oh no, they want to get the plaintiff into the position as if the contract had been fully performed as they had expected it to be performed. And that's a really super big difference, because think about it, the first thing is what comes to my mind is what we call expectation losses. That is, what's the amount of profit I intended to make out of this contract? And if you can make a decent argument to the court, I expected to be in this position if it weren't for that breach and this termination, the court will put you into the position with an award of damages that will get you to the point as if the contract had been fully performed. And that's awesome from a plaintiff's point of view. So really super big difference between the notion of rescission and the notion of termination, the notion of what compensatory orders are part and parcel of the remedy of rescission, and then that extra ability to claim for damages sometimes that sits along the remedy of rescission, like, for example, for fraudulent misrepresentation. And then, on the other hand, breach, termination, loss, and damages in contract, which puts you right to the end point of the contract being performed. Does that make sense? Really big difference. And I noticed that a lot of people got tricked by the remedy of rescission and the whole issue of rescission and remedies in answering this week's IRACs. So hopefully that will steer you in the right direction. The other thing, we know how rescission can be destroyed. So we have all of the usual latches, which is delay, affirmation, we have third party rights. We have sometimes if the contract has been completed, but that's normally only for sale of land, and all of those things. So obviously you can lose your right to rescind. You might still have a remedy in damages, but in terms of termination, if there has been effective termination, that's it. It just stands, and then the court works out what position you should have been in if the contract was performed, and you get your damages accordingly in contract. I hope that has steered you in the right direction. Some of you look a little perplexed. How are you feeling about all of this? Give it to me, peeps. Feedback.
There's a lot to it.
A lot to it. Yes, there is, but it's extraordinarily logical if you think about it. Yes?
Yep.
Yeah, I'm finding it really not difficult as such, but just pretty full on, and trying to keep all the concepts in my mind going, because they seem to cross over quite a bit. So I was confused about damages because I thought you couldn't have them as compensatory damages. So I was obviously confused with the reading.
Yes, and a lot of people were. Often what will happen is, you'll just get a whole stack of orders that are made in terms of the rescission. There is a really good case that explains the whole remedy of rescission, called Alati and Kruger, and it's in your case book, and it's in the week 4 readings on misrepresentation. And it's a cracker of a case because it really helps you to get a handle on the very powerful nature of rescission. And because rescission is your equitable remedy, you know, how well it can be tailored to fix up a situation. I mean, there you had a misrepresentation being made as to the kinds of takings that a business was making, and there were circumstances in the surrounding factual matrix that meant that any business takings of that particular shop were going to be almost nil once these facts had come about. And the purchaser went through with the transaction. They did the sale of business. The business was changed over hands. The purchaser started to operate the business. The purchaser then realised that there'd been a misrepresentation. They tried to make the thing work. Ultimately, they shut up the shop. They'd sold off the assets. So it was, normally you would think, restitutio in integrum, how on earth? Surely the right to rescind has been lost. I forgot to put that down here, didn't I? Restitutio. Oh, it keeps it keeps correcting me in integrum. Surely that would be lost if all of that subsequent, matter had occurred. But they actually unpicked all of the results and managed to do justice between the parties in the orders that were ultimately handed down. So it's a really useful case for you to think about rescission. And if you have any queries, shoot through a question to me. I did note that the case, just the textbook discussion on the measure of damages was not too bad, actually. It does talk here about Alati and Kruger. Yes, here it is. 13.13 was the measure of damage. Mm-hmm.
I think where I got confused is I thought that damages was just for a loss, so they couldn't award anything other than for losses.
Yeah.
Is that right, or they can actually award additional?
Generally speaking, you will only get damages for a loss that has been suffered.
Yeah. Okay, cool.
But there are some areas of law that will impose additional damages by way of deterrent.
Okay.
But that's not up for discussion now.
Yeah. So in contracts, in this part of the course though, we're pretty much on that concept that it's for losses.
Yes.
Okay, cool. So I did read it okay then.
Yes, absolutely.
All right, awesome.
It's quite a nice little discussion. They actually contrast the measure of damages in tort and the measure of damages in contract like we did tonight. So that might be useful to just quickly go and have another little look at, now that you've got it a little bit straighter in your head. Yeah, hopefully that makes some sense.
Yeah, thanks.
Any other queries on that? Any other general thoughts? No? All happy chappies? Okay, guys. Well, if you don't have anything else that you wish to discuss, we'll leave it there. And thank you very much for coming. I hope you found it useful. And that is equity so far as contract B is concerned. Thanks, guys. Bye.
Mm.